Okay, with the quorum being present, Dr. Duran, you have some presentations to make?
Yes, so we're back here. We had said last week was Mary Ann's last presentation, but so maybe this will be her last presentation since
I mean, she's not, her
Friday.
retirement reception is not until Thursday.
Thursday,
correct?
but
You know,
so
we
we're
still have a
back,
couple more
yes.
nights to schedule additional
Yes,
meetings.
yes. So we have our, Teresa Johnson, Mary Ann Panarelli are going to lead us through a presentation and the PowerPoint, which really, we're not going to go back through and represent all of the changes. Actually, what we're going to do tonight is talk about the revisions since last Monday. So we want to highlight what has changed since last Monday. And we're really happy that our three principals are back as well. And if you have questions or comments, they can certainly engage in that conversation when we come up for questions. So again, the focus of our presentation is really the revisions that have occurred since last Monday, based upon board member feedback, suggestions, and also some additional research that we have done.
Okay, Dr. Duran, I forgot to mention one thing, that we have a closed meeting scheduled.
Correct.
At about, now it's going to be at about 5 o'clock, maybe, slightly before 5. Once you make your presentations, before the board members do get into discussing
Yes.
various different points, I think there's some legal advice our division counsel wants to give us in closed meeting. So we'll do that and come back out.
Yes.
After the closed meeting, we'll do a public discussion after that. Okay?
So with that, we have about 15 minutes. I will turn it over to Mary Ann Panarelli for this time, your last.
Okay, so in terms of additions, in the introduction, we put in a sentence about meeting unique needs of students, which was one of the requests from the board. On page 8, we indicated that parents would be notified when there was a search done. On page 11, we added language referring parents to the ombudsman's office if they had some questions about how to make a complaint. And on page 11, we also indicated that staff are mandated reporters when it comes to Title IX violations.
And as we turn to the next slide, if you follow the regulation, which was also a document we uploaded, everywhere in the regulation where we're referencing these changes, you will see that highlighted. So you can identify on the page the actual highlighting of the words and see what was exactly changed.
Okay. And then in terms of, there were a number of questions about what would constitute a substantial disruption. So a definition of substantial disruption was added, and you can find that on page 58 and 59. In terms of the charts, there were a number of things that were done both to align with recommendations of the consultants. This first one in particular was to sort of have a level series of sanctions. So a level 2 was a maximum of 2 days in school suspension, a level 3 is a maximum of 2 days of out of school suspension, and then a level 4 is a maximum of 3 days for K3, 5 days for older students unless there's a referral to the superintendent, because the things that are in level 4 are those that, depending on the circumstance, might go to the superintendent. We also just removed it. In looking at this again, I became aware of the fact that we had a duplication where we referred to posting demeaning pictures, so I just removed it. If you go to the charts again, we adjusted the consequences for alcohol and other drugs and the bullying to align with the level changes so that the X's on the chart align with the words that are in the narrative. And in doing that, we also sort of aligned alcohol and marijuana so that there was a mismatch that was brought to our attention the last time we were here. We added a footnote about the alcohol offenses that mirrors the marijuana offense. We also added a key for the codes that we were giving to the principals to ask them to code certain behaviors in a certain way. In terms of changes, again, in review of this, I became aware of the fact that we still had left absenteeism as a discipline violation. In fact, that's not going to be reported to the state as a discipline violation. The absenteeism will still be obviously captured as the child was absent, but it's not a discipline violation. Adjusted the consequences for first-time tobacco and vaping to 2 days of in-school suspension and interventions. In terms of student activities, I'm going to read this because this was something that is a pretty substantial change. Some of it was clarification, but some of it also represents a change. So we say that the violation of this subsection shall result in temporary removal for X calendar days, it's different for different offenses, from all student activities, including competition or practices in teams, clubs, and all other activities, such as, but not limited to, homecoming or prom, including attendance as a spectator or as an audience member. Students may be allowed to participate in convocation and the graduation ceremony, even if they fall within the timeline of the temporary removal from activities. Certain violations, and there's a footnote there, will result in the student being ineligible to attend graduation. And the next page shows you those footnotes. These types of violations may include, but are not limited to, assault on staff or students with injury, sexual assault, possessing of weapons or explosives, possessing of drugs or controlled substances indicative of an intent to distribute, distribution of drugs or controlled substances, or any violation that would cause a clear disruption to the graduation ceremonies. The decisions to exclude a student from graduation may be based on a decision from the hearings office or may be made by the principal in collaboration with the regional assistant superintendent. So again, we're looking for some level of consistency across, and we felt that the best way to do that was, if there's going to be a decision to exclude a student from graduation, that would be made in partnership with the regional assistant superintendent. In terms of parent notification, we added a couple clarifiers. No student 8 or younger will be asked to write a statement. And then, again, this was the same thing that we presented before, but it has some clarifying things. So in the event that the administrator has reason to believe that the student has committed an offense that would result in referral to the division superintendent, or has a first-time drug violation, which I think Ms. Evans asked for, the school administrator shall make reasonable efforts, for example, phone, text, email, to notify the student's parents as soon as possible before questioning the student about the alleged offense. School administrator shall document the parent notification efforts, including time, date, and method of notification. And again, some of that was at the recommendation also of the consultants. In terms of educational placement during the appeal, this is not a change as much as it is a clarification that there are a couple options for a student as they are appealing. They certainly could go ahead and register for the location that the letter says that they should go to. So in other words, if they have been recommended to the alternative high school, they could go to the alternative high school even while the appeal was pending. As an alternative, the student may continue to receive out-of-school support assigned by the Office of Intervention and Prevention Services to assist with the completion of assignments. So as soon as a student is recommended to the hearings office, as soon as we get the letter in the Office of Intervention and Prevention Services, there's outreach to that family, and we set up a teacher to work with the child to keep abreast of what's on Blackboard, to arrange for tests if that's necessary, to answer questions that the kids may have as they do their assignments, and just in general to support them while they're at home through the hearings process. That could continue and often has been continuing when there's an appeal situation. In terms of students with disabilities, again, I'm going to go ahead and read this just because the whole of it is new. FCPS looks at every student and their unique needs and wants to work collaboratively with each family to support their child's needs. For students with special education services, the IEP team, to include parents, requires that each child's unique needs are reviewed and considered during the IEP process. When a disciplinary incident involving a student with an intellectual or developmental disability may result in a suspension of any kind, school staff shall not request a statement from the student until the parent has been notified, unless exigent circumstances exist. And then we changed to shall. The results of the MDR shall be made available prior to any hearings office proceedings. You will recall that If it is a manifestation of the student's disability and there is not a victim, it will go back to the school. But if there is a victim, it would go forward to the hearings office. Or if it was not a manifestation of a disability, the law says the student should be treated the same as if they didn't have a disability. So it would go forward to the hearings office. In terms of technology, the Department of Information Technology has recommended a number of revisions to Regulation 6410, which is included in the SR&R Guide for Families as the Appendix A. So that's been updated, and I believe a copy of that was sent to you and posted on board docs. The revisions include student rights and guidance on school-issued versus personally owned devices. You want to go this one?
Click. On this next page, slide 13, staff did review the request for the amendment, and the staff suggested no additional changes at this time. I believe this is a consideration for more conversation in closed session. The next change, this is some clarifying information about the Second Chance program. There was a lot of discussion about this at our previous meeting. On slide 14, you'll see what FCPS is currently proposing for our plan and what's been included in proposals for the SR&R regulation. Just to repeat from last week, changes for first-time use and possession of marijuana, THC oil, unauthorized prescription drugs, and imitation drugs in an amount consistent with individual use. These would be the students that would be going to the AOD seminar, and this first time, again, would not be referred to the hearings office or the hearings office process. We also are proposing that our students would continue to attend the AOD intervention with follow-up services. If you recall, last week we talked about the number of steps that we were going to take to follow up with students and to refer them to the appropriate services based on their assessment. And the next one, we did meet, Dr. Panarelli and I met with representatives from the juvenile courts, and we are working to draft an MOU so that we can fully implement a similar program. And we are all asking, through Dr. Duran's equity plan, asking for year-end fundings for 7 substance abuse prevention specialists. On the next page, just to give some comparisons, the Second Chance program at Arlington, this is how we're a little different than Arlington and what we're proposing. In Arlington, first-time possession and use of all drugs that are of misdemeanor violations move forward to the Second Chance program. They also include students that are court-referred, and again, we're working with our partners on the county side in order to implement something similar. They do not have a 2-day in-school suspension. They have a 3-day program. And looking at our needs and our resources, we would be requesting funding needed for additional substance abuse prevention specialists to fully implement the program in coming years. And that's about all that we have for you. At this time, Mr. Moon, I'll hand it back over to you.
Okay, if there isn't anything else to present, Madam Chair?
The board will now make a motion to go into closed meeting to, 1, consult with legal counsel regarding specific legal matters or actual litigation requiring the provision of legal advice by such counsel, specifically Title IX and other federal matters, special education matters, and Doe v. School Board, civilian number or court number 118 CV 614 ED Virginia pursuant to sections 2.2, 3711 A3, 7, and 8 of the Code of Virginia. Do I have a motion? Motion made by Mr. Moon, seconded by Ms. McLaughlin. All those in favor? And that is unanimous with those at the board. And staff, thank you so much for being here. We are going to go into closed meeting, so make yourself at home with coffee and water and anything else? Okay. We should be, I don't think this will take more than, what do you think, Mr. Moon? What did you slate for this? Hopefully about a half an hour? Yes. Okay, we're gonna shoot for a half. Just regarding this? Yes. Okay, well, maybe an hour, but if you can just stick close, thank you.